Hello, everyone. We're going to give a minute or two for everyone to join. Looks like we got a couple people joining. We'll get started shortly, though. Okay, so it looks like we're leveling off. I'll give people a chance to join, but I'll start with a quick intro. So welcome, everyone, to our latest in our series of defined contribution legal and regulatory webinars. Today, our topic is to look at record-keeping contracts and the ever-evolving nature of those contracts. As I'm sure most are aware on the call, record-keeping fees have been driven lower by litigation and also really an overall focus on benchmarking plan fees. The NEPC annual fee review is a good example of that. But with that, revenue margins have shrunk down. This increased focus has driven fees lower, which has been a really good story in the defined contribution market. But record keepers have gotten more creative and actually offered services that are useful for plans to kind of enhance the plan offering, but also increase their profit margins. So these enhancements have been great for participants. So this isn't meant to poke holes in any of these things that are added to plans. But what we did want to do is kind of shine a light on the fiduciary side of that and the responsibilities that get increased as you add these enhancements to your record-keeping relationship. So with that, we're going to look at it from a legal lens. And to do that, I'm not a lawyer and none of the consultants here at NEPC are, although I did see Legally Blonde a few times, so have a little bit of a legal background. But in terms of experts, I brought in two today to help us look at this from a legal lens. On the screen here, we have Tim Ahrens from Dorsey & Whitney and also Andrew Hawley from Dorsey & Whitney. Both Tim and Andrew are partners at Dorsey, and Dorsey is recognized as one of the leading benefits and ERISA practices in the country. So they're going to look at it from kind of two sides of the legal lens. So the bit of a different role for both of these gentlemen on the call. Tim has more of a focus on clients and helping them through contracts and sitting in quarterly meetings. Actually, Tim and I share a client, so I've seen Tim in action. Andrew defends clients in the courtroom. So if there's a new or ongoing litigation, Andrew gets pulled into the relationship or added to a relationship to help with that. So one keeps you out of the courtroom, the other helps you when you're in the courtroom. So to simplify it in layman's terms. So we're going to spend about 30 or 40 minutes on the different topics. Really what we want to first hit on is the history of lawsuits. We'll do kind of a quick run through of those and then go through the new definition of bundled arrangements. So NEPC clients are used to hearing how we classify a bundled arrangement as, the old definition was proprietary investments, that being a part of the lineup, and those proprietary investments or revenue sharing investments would pay for the record keeping costs. Now there's obviously more services involved with that. So getting that bundled quote unquote relationship is what we want to kind of hone in on. Andrew will go through, some just the basic facts of ERISA. So for non-ERISA plans, we'll do a quick dive on that, and then talk about some of the best practices that actually flow out of non-ERISA plans as well, cast a wide shadow. So it should cover a lot of the best practices there. And then we're going to do a couple cases. So there's a Tussey case that was one of the original lawsuits out there that went through a lot of twists and turns, and then a recent AT&T case that again has gone through a few twists and turns, but is starting to kind of shape the future look at what litigation is going to do to best practices. So we'll finish up with a really deep dive from Tim on best practices, but that's our agenda for the day. You're all welcome to have questions as we go. I'll try to keep an eye on the chat box here, but there is a chat box in your window that you can type in questions that we'll try to get to all of those as we go through. So with that, I'm going to turn it over to Tim to give us a quick dive on the history of 401k cases.
Okay, maybe we can move the first slide. There we go. So the litigation activity around fees really kicked off around 2006, and since that time, as we've got on the slide, there've been hundreds of cases of various sizes and types, but many of them focusing on the pension plan investments and record keeping arrangements, and really focusing mostly on fees. And fees come into play because obviously it's a fiduciary issue, which we'll get into a little bit later, in terms of minimizing plan expenses and whatnot for plan participants. But over the past, we'll call it 17 years, we've got about $6 billion in settlements so far. And when you think about the dollars that are involved in some of these plans that are subject to this litigation, you've got plans with billions of dollars in it, even a few basis points adds up. And so that's how we kind of get to the $6 billion in settlements in terms of kind of what's going on. The other thing that we're noticing in the 401k world is that the litigation isn't slowing down. In fact, I would say, and Andy can speak to this better than I, but it's actually probably picking up. And what's happening, I think, is the plaintiffs' bar is actually even going down the scale in terms of size of plans. As we note in the slide, plans with less than $1 billion of assets are getting hit. And we've even seen some, Andrew and I are in the Twin Cities, we've seen, I remember the body shop case here, Andrew, that from a few years ago, where they were targeting a 401k plan from a regional body shop here in the Twin Cities. So they are going down the scale in terms of size, and so we want to be in tune to that as well. Record keeping arrangements are really one of the consistent focus areas of these suits, and largely because as Dan alluded to earlier, you got various fees out of these arrangements, and they're just much more easier to find, I guess, than what they maybe have been in the past. One thing that I guess isn't on the slide deck, and Andy, maybe you can speak to a little bit too, is how these cases come up. Where do the plaintiffs find their cases, and how do they find plaintiffs?
Yep, and that's an interesting thing. And just to kind of reiterate one of your points, we are not only seeing smaller plans being targeted, but we're seeing additional plaintiffs' lawyers being interested. We are seeing lawyers who are some involved in employment lawyers, wage and hour lawyers, who are seeing all this money that other lawyers are earning off this. That's $6 billion in settlements. It's very common for plaintiffs' lawyers to say, I want 1/3 of that settlement, and make a lot of money off it. And so now we're not only seeing the other plans targeted, but we're seeing other plaintiffs' lawyers get targeted, being interested in this. And naturally, when you have a new lawyer interested in it, that lawyer is going to find a target. It's pretty amazing for people who are not familiar with this, how it happens, but you will see Facebook ads saying, do you work for company XXX? Please get in touch with us because we think that you've been defrauded, or we think that your company has done a poor job of managing your 401k plan. You'll see it on LinkedIn. You'll see, once upon a time, I don't know if it's still there, you'll see there was a website called www.erisafraud.com that did just that, solicited plaintiffs. The plaintiffs, the individual workers, are not the people in almost every instance who start these processes. It's the lawyers who start the process, and then they go find a plaintiff to represent a class, or at least a putative class. The sources for these things, I mean, ERISA has a very, very detailed disclosure regime, right? And so a lot of information is found online in your 5500s, and a lot of information can be accessed by the participants. And if one of the takeaways from this is that you should be very, very careful about formal requests, and obviously drafted by lawyer requests for plan documents and information, because that is very, very commonly the first step into a lawsuit. So that's, you can get at least some. I would be very careful about that, and instruct people in HR that if you get strange requests for documents and information, that's something you should, that should raise a yellow flag for you. You should take a look at that. But we wanted to talk here today about a very specific area, kind of a growing area in these 401k fee lawsuits, and that's this shift. You can go forward. And that's the ship that we've seen towards a new towards sort of bundling of record keeping services. Once upon a time, that term was referring more to just the record keeping service itself and maybe some investments that a provider offered. And now what we're seeing, and part of it's technology driven simply because there's more things out there, and part of it's the normal changes to the marketplace. But we're starting to see more of a movement towards record keepers offering ancillary services to 401k plans. Now, those, and we certainly don't, as Dan indicated, we certainly don't want to come out here and saying that these are always bad, or that they're things that you shouldn't consider, or that you're creating a massive litigation risk. That's certainly not true. These services can be very helpful for participants, but if there's a theme here today, it's that these things, that the tires need to be kicked, and that you need to look at these things, and you need to look at not only whether or not these are good ideas for your participants, but how they're paid for, where the money flows, and things like that. Because if you don't, as we'll see, you have a real risk of litigation and a real risk of significant damages. Again, just a couple of examples of these sort of bundled relationships we're seeing. We've seen in the past, is not as common, the idea of proprietary investments. A service provider will say, look, we'll give you cheaper record keeping fees in return for using our proprietary services, our proprietary funds. That's a very common one. That's one that's been around for some time. But we're seeing more, though. We're also seeing people looking for people asking to get access to give access to your participants to individualized investment management services. These are often services that use some sort of algorithm to help your participants, in theory, invest properly given their particular circumstances. Now, those may well be great ideas, but they certainly charge a fee. And as a fiduciary of a plan, you certainly need to be analyzing, not only is that a good idea for your participants, but where that money's coming from. As we're going to talk about in several cases, those providers oftentimes share revenue with record keepers, and that needs to be evaluated and understood. Brokerage windows, exactly the same thing. Giving participants the access to the whole market seems like a great idea. Why wouldn't participants want more choice? That's the point of a 401k plan. Okay, maybe so, but where is the money coming from, and how are the service providers being compensated for that? And is there ways that you can use the fact that that service provider is being compensated to drive a better deal for your participants? Because that's, in the end, what a fiduciary is really supposed to be doing at some level. Use of plan data is another thing. And one thing that we're seeing is, to a certain degree, is and this is something that I can tell you right now that the DOL would be very excised about, is service providers having access to your participants to entice them or to encourage them, or at least give them the opportunity to roll over their money into individual IRAs. And again, not to say that this is a service that should never be provided, but it is something, for example, that the DOL would be very concerned about, because in their view, right or wrong, that IRAs are more higher cost and really don't deliver value to participants. So again, and inevitably that will, if the service provider has access to your participants, that's a revenue stream. And it's something, as we're going to talk about, it's something that needs to be evaluated and needs to be priced in if you are as a plan fiduciary.
Yeah, and I'll add from the consulting perspective, as you look at the different offerings here on the slide, something like brokerage window, that's usually put in place by a plan sponsor to say, hey, we want to compete for those IRA rollovers. If we find that people are rolling money out of the plan, maybe if we add a brokerage window, they'll be more inclined to keep it in there. So again, reiterating the fact that these aren't always negative. In some cases, they're put in place to counteract some other revenue streams that could be generated by the record keeper. So as we transition here, introducing these new bundled services or more ubiquitous bundled services, if we talk about that and the ERISA framework and in terms of the fiduciary responsibilities, how do these bump up against that? So obviously, I think the old school record keeping contract was a little bit more simpler to quantify, and now how do you go through the fiduciary paces of these new offerings? So maybe Andrew, if we can talk about that for a bit.
Sure. We can flip forward. So ERISA is famously very, very complicated. and very, very detailed, and even compared to other areas of law, it's famously reticulated. Is the first line of every Supreme Court case dealing with ERISA is always, ERISA is really, really complicated and really, really hard. So even the Supreme Court has challenges in interpreting it, right? And we could have an entire seminar simply on the fiduciary duties of an ERISA fiduciary. But I can summarize these as a couple of things. So first of all, you have to be prudent. And that just simply means being wise, careful, and attentive, and looking out for the interests of the participants as a expert would. And the second thing you have to do is be loyal. And that means you cannot use your status as a plan, your plan assets, your power over a plan to benefit yourself. That is a very, very strict rule. And one of the very unique aspects of ERISA is not only are these just sort of general legal standards, but they have these things that are called prohibited transaction rules. And we could have an entire seminar on them. But basically, what they say is that there's some transactions that are absolutely forbidden and you are immediately liable unless you can come into court and prove that they're a good idea. And that includes, at least arguably, at least to some according to cases that are coming down, that includes all of your contracts and all of your amended contracts with service providers. Again, at least there's some authority that say that. So they generally say your contract with this is one interpretation, is that your contract with your service provider is illegal and forbidden unless you can come in and prove that it's not. And so that's a very high burden. And when dealing with these rash of 401k cases, people should at least have some attentiveness to what could possibly happen in litigation. And one of the themes we'll talk about today is to make sure that you're prepared, at least at some level, for that litigation by preserving documents, by preserving information, and by showing what the last thing there, procedural prudence. This is probably the most important phrase that I deal with as a defense, and that is essentially saying that ERISA recognizes, the statute recognizes, the court recognizes that you are making decisions based on imperfect information. You are looking at the world as it is right now. There are any number of trade-offs that a plan can make in terms of investments, in terms of record-keeping fees. It's not always good just to be the cheapest. Somebody can certainly say, we want the Cadillac of record keepers with all of that entails, and so that might be more expensive. There's any number of choices that a plan fiduciary has, so long as they're acting loyally and not in their own interests for participants. The critical issue, and the first and critical issue in any ERISA case, is are you going to be able to show to a court that the decisions that were made by a fiduciary were intelligently considered, were careful, and looked at the pluses and negatives of a particular choice. And once you've done that, you have a great defense. But as we're going to see from a couple cases in a second here, if you haven't done that even just the inability to show that you were just attentive to things itself can be a fiduciary breach. So again, one of the themes that we're going to talk about here, and one of the best practices, is to make sure that your decisions, your reasoning for your decisions, your thoughtfulness in your decisions are well documented. So if a day comes when you have to call someone like me and say, how do I get out of this lawsuit, you're going to be able to show that your decisions, your process was careful, thoughtful, and prudent. So now we're going to go ahead, Jay.
One other thing I might want to interject, and you might want to comment on, Andy, is who is a fiduciary? I mean, normally think of like the committees or typically it's a committee would be the fiduciary, but it can move up and down the chain, really. I mean, it's who has discretion over the plan type of thing. I don't know if you wanted to comment on that at all.
Yeah, that's a very good point, Tim. And one of the issues that you oftentimes see in companies is that you'll have a mix-up of fiduciary responsibility, really at a very high level. And again, another topic we could go on for some time. Anybody that's making decisions for a plan is going to be a fiduciary at some level. That doesn't mean a decision about what the plan terms are or what benefits we offer. That's not a fiduciary decision. But once it's established, if somebody's making a decision for a plan, you have to think that you're probably going to be a fiduciary. And one common thing we see about record-keeping fees, everybody knows that at some level about investments, and everyone knows that they have to be careful to choose investments and things like that. But one of the things we see about record-keeping is that it seems like just a service contract, and so therefore the committees and the CFOs who are analyzing investments aren't necessarily paying attention to that. And that oftentimes just go into HR, some person at HR who's responsible for those service contracts and responsible for that. And they may not be attentive to the fact that they're a fiduciary, and they may not be attentive to the fact that the choices they're making are fiduciary ones that could expose the company to liability. So again, one of the things we're seeing in this case, in our presentation, is that it's very important to make sure that you have a clear and understanding of who's making the choices for your plan and what those choices are and what the implications of those choices are. There are a million ways to do it. There are a million ways to divide up and allocate responsibility. But as with everything we do under risk, it needs to be intentional and thoughtful and making sure that, that you're doing what you say and you say what you do. We're going to talk next about two specific lawsuits. One is an older one and one is a newer one. And I say this not because, I realize nobody wants to know the nitty gritty of the law or the how you get to go to trial or summary judgment or the burden of proof or anything like that. But I think what they do is they give you a good sense of the facts and the issues that you see in these bundled relationships, bundled record keeping relationships. The first one we're looking at is a case called Tussey versus ABB. And this is, one of the things as a litigator, my job is to make sure everybody realizes how awful litigation is. And the one thing I can tell you about this Tussey case that will show how awful it is the case I believe was filed somewhere around 2007. And I know it was going through 2019. They had two separate appeals to the 8th Circuit. And so that's a solid, if my dates are right, that's a solid 12 years of litigation that this company was dragged into it. And you can imagine what the litigation fees look like and just the drain on resources of the company. And this was, again, one of the first challenges here to bundled record keeping relationships. The relationship was a little less sophisticated, a little less detailed than what we have today in our many situations that we've been talking about. Essentially, it was a very common practice. The fund provider, the plan had a relationship with Fidelity. Fidelity had a platform where where funds that the fiduciaries chose from, and Fidelity got compensated for its record keeping services based upon revenue share. The company thought this was great. The company felt like it could tell participants there's no fee for you, and that in theory was, at one level it was true, but another level it was not true, because there were certain participants who were invested in higher cost investments, and a portion of that cost went to Fidelity. Now, nothing wrong with that particular relationship. Nothing wrong. It's certainly a reasonable fiduciary could make that choice to use revenue sharing to pay for record keeping expenses. It's less done today than it was back then, but back then it was almost ubiquitous. The fiduciaries got in trouble, however, because when they were evaluating Fidelity's services and the relationship with Fidelity, they were not asking questions about what Fidelity was receiving. They just felt like this was free money, free service to them. Whatever happened between Fidelity and the individual funds was just not their problem. And they didn't attempt to ask Fidelity what they're receiving. They never went to Fidelity and said, look, you're making a lot of money off us, way more if you look at the whole relationship than what other plans of our size would be charged. And that was a big problem for a court, right? It was a huge problem for a court to be able to say, you need to be evaluating these things, even if it's not coming directly out of your pocket. Fidelity's making that money, and Fidelity, you have the power and the duty to try to manage that relationship and drive the best deal for participants, even if it's not coming out of their pocket. And probably the most critical fact that the court focused on, and this goes to the loyalty point that we had just talked about before, is that the plan, or the company was actually benefiting from the relationship with Fidelity. And by that I mean the company was not, the plan fiduciaries were not focused on the relationship with Fidelity. And in fact, that business with Fidelity allowed the company in its private interests to get better deals from Fidelity on other things. And that's, from the court, that was a breach of the duty of loyalty. You cannot trade off participants' interest in record keeping fees and participants' interest in the plan by getting benefits on the other side of your corporate side. That kind of bundled relationship, according to the court, and would just clearly violate the fiduciary's duty of loyalty. And again, just to show, not only was this 12 years of litigation, but it resulted in a $13.4 million judgment with interest that would be added onto it. And under ERISA, the plaintiffs would get their attorney's fees. So that's a lot of money and a lot of time and a lot of energy to be devoted to this sort of litigation. We're now going to talk about a more recent case that just came down from the Ninth Circuit, which is out in California. We can flip forward. And that was it's something that really had shockwaves throughout the ERISA litigation and device community. And this is this AT&T services case here today. And it really reflects the changes to bundled record keeping services and those arrangements that we're starting to see prevalent more and more today. And it gives you a sense of how these things need to be analyzed. I should mention, I mentioned this earlier, I should mention that ERISA only does not apply to governmental plans. And there are probably some people here who are, manage governmental plans. And so ERISA itself won't apply to you. But first of all, there will be state laws that do, and some of them are very, very similar to ERISA. And second of all, even if it's not a legal issue, certainly the things we're talking about here are best practices. So the facts of the AT&T case. Essentially, what happened is AT&T had a relationship with Fidelity again, and in 2012 and then in 2014, the AT&T executed an agreement first with Fidelity, adding the brokerage link, which, as Dan indicated, can be very helpful for your participants, especially if you're trying to avoid rollovers and just give people more access. So again, not suggesting that these are inherently bad ideas, just something that needs to be watched. And then in 2014, they added this financial engines product. And this is one of those investment management products that we talked about before, where the participants can add information for a fee. Financial engines will provide them using an algorithm with a tailor-made investment choice. Now, we talked about before the real legal issue, and I won't get too much into it, but the real legal issue in this case was the prohibited transaction rules. Remember that those are the rules that say that you're liable unless you prove you're not. And what the court held here was each of those amendments to the contract was subject to the prohibited transaction rules. That means that they are illegal unless you can come in and show an exemption applies. And here the exemption is one that shows that demands that the compensation paid for these services must be reasonable. So again, you are in court and you are adjudged to be liable until you prove otherwise. That's a high burden. And again, one of the themes here is to say that we need to have documentation and evidence to show why you did it and what the reality was. It's very important. So what did the court really come up with here? The most important thing that the court came up with here is and this is also true of the Tussey case. It's entirely possible that the relationships that AT&T had with Fidelity and adding these particular products were prudent, appropriate, and could have been defended. The problem was that there was testimony from the fiduciaries of the AT&T plan that they simply didn't care. It was simply, they did not feel like this was their issue. You see the two quotes there below. There was testimony that AT&T really didn't make an inquiry about whether the fee paid to financial engines to Fidelity was reasonable. So on the back end, financial engines was added to the plan. Nobody challenged that. Nobody said that was improved. Some cases do challenge that, but not this one. And financial engines was paying money to Fidelity on the side, basically saying, thank you for giving us access to this plan and paying us for some of Fidelity's services. Well, the court was incensed, or the court was found it important that the plan never asked, hey, Fidelity, how much are you making from financial engines? That's a lot of money. We need to negotiate down our record keeping agreement. You need to provide us with some value for that. As a service, you are getting a benefit. And the managers there was at least some evidence that the managers of the AT&T plan were not interested in that. And they said that this is not our problem. We are concerned about the fees our participants are paying, and that's it. And the court had a problem with that. And a decision that the Ninth Circuit, as I say, reverberated around ERISA circles. The court had a problem with that and said that you need to be looking at all the sources of income. You need to be understanding your relationship with your service provider, and you need to be looking at these bundled services to make sure, number one, that they're prudent for your participants. You shouldn't just add these things on without thinking about it, but also that you understand the whole sort of constellation of your relationship between your plan, your service providers, and their relationship with one another. And that's the takeaway from this case. So it really speaks to the idea that a fiduciary needs to be looking at all of these things, and inevitably that they have good advisors who are able to understand this stuff, like NEPC, understand this stuff, and be able to provide this and understand these relations and have the wisdom and understanding what that looks like.
Yeah, and I'll add to that too. You know, NEPC, as I'm sure most clients are aware, we have extensive benchmarking for clients with these two services. So you know, we can show what the typical fees are that we see on those. But with that, let me just ask a quick question here for Andrew. You talked about, you know, things that are add-ons to plans that may seem free, but as I'm sure we're all aware, in all parts of life, nothing's free. So is there a method, you know, if it's not going to elevate to the committee level, but you're you know, asking Fidelity or whoever the record keeper is an email sufficient to say, hey, do you get anything from this service? And is that when you get to the litigation stage, is that defendable, or does it have to elevate to a committee meeting? You know, just give us a sense of what level of papering the files is helpful, and what is it, what falls short?
That's a great question. So first of all, do keep in mind as you're thinking about these things that there's, you know, one of the things that has become more helpful for plan fiduciaries is that there has been increasing disclosure of these sorts of fees over the years due to DLO regulations. So you should have a fair amount of information accessible to you in the first instance. It's challenging to, there's no right answer to your question. I think that the most important thing is not so much the form of the deliberation, it's not so much the form of it, but it is more the substance of it. And emails can certainly be appropriate ways of communicating and things like this, but they do need to reflect a careful process. So, for example, I would have no problem with a detailed email and shared with the members of a plan committee, documenting and describing the hour-long meeting that you had, where you went through the back and forth of this thing, and you decided this and that and that and this, and you weighed the balance. You decided that this was the best thing to do. The fact that it's not necessarily in a formal, you know, committee minute is less important to me than it shows the deliberation. The danger with emails sometimes is that they can be very surface. Aren't detailed enough to really provide the sort of evidence that you really want to see. And again, you know, some decisions fiduciaries can certainly be criticized for doing nothing more than simply having email communications amongst each other without really deliberating. So I would be less concerned about the form of it, but more concerned about, does it reflect the deliberations that actually happens? Does it reflect the fact that you looked at the trade-offs and you made this decision to go with A rather than B for good reasons, for intelligent reasons? You know, obviously there's always a certain in trial or in a deposition or in a summary judgment motion, there's also always a certain benefit to having things look pretty, you know, so that's something you can think about, but always more interested in the substance than anything else. And again, the problem talking about these things in the abstract is the importance of the decision somewhat drives the method for the decision-making process. That helps.
Great, thanks, Andrew. Very helpful. So maybe at this point, we're just getting past the 30-minute mark, and we'll go to our kind of last topic here is the takeaway here, the best practices. So Tim, if you could walk us through those.
Sure. I mean, some of these we've hit on kind of as we've gone through the litigation aspects and the do's and don'ts, but really number one is understanding your service provider compensation, peeling back the onion and trying to sort out who's getting paid for what and why, and making sure that you understand that compensation structure. So many times they're complicated arrangements, there's lots of moving parts, and it's difficult to do. And that really gets to the third bullet point, getting expert advice and evaluation. I'll skip number 2 for now, where you can utilize the service of outside counsel or consultants like NEPC that are really experts in the field to help you do that. Most of the people serving on committees are not, this isn't their full-time job, and it's not, they're on the committees to assist the plan sponsor, and many times they bring a lot of different perspectives to the table, but they're not industry experts in what's going on in the 401k world. and to be able to add some expert advice and evaluation to that process is both helpful, and I think Andy would probably agree, helpful from litigation context as well. Item number 2 that I skipped, evaluate and consider all possible arrangements. I mean, here what we're after is we're not just going to have one vendor on our search and we're going to just take them. The better practice is to really go out to bid for these types of arrangements and involve a number of different possible vendors to analyze and really demonstrate that you are going through the prudence of determining what's going to be best for the plan participants. The 4th bullet, negotiate agreement terms prior to the final selection. I mean, this is really more of a practical contract negotiation issue. But the bottom line is once you've selected the vendor, they're much less likely to want to move off certain agreement provisions. And where you have the leverage is when they're still in a competitive bid situation. So what we would normally like to do is ask for those contracts as part of the proposal, so that we can see what it is they're actually going to ask us to do and what those fees are going to be up front in the competitive bid situation. Document procedural prudence. Andrew touched on that a little bit from Dan's question, but part of ERISA's requirements or how you're going to be evaluated in litigation context is what was your prudence or your documentation rather that really sets forth what you looked at, what you did, and how you came about your decision. And it's almost more important than what decision you make that you actually went through a process and that process is documented so that you can demonstrate that you did follow a prudent process in selecting vendors and evaluating fees. Andrew talked about this as well, avoiding any hint of disloyalty. For example, a vendor will throw in administering an executive compensation plan for nothing as part of the package. Well, that's really, you're getting something for those fees, and it's, you need to really peel that onion apart and figure out what really is applicable to what, so you know what you're paying for in the 401k plan. The other place this comes up is if there's some other financial relationship that the vendor has with the company that's outside of the retirement plan context, and be wary of situations where you might get a discount outside the plan context for bringing the plan business to the vendor. Those would be extremely frowned upon. We talked about are the bundled services really in the plan and participants' interest, and there needs to be an evaluation of that, not just adding them on and throwing the expense into the plan. And then being worried about closed arrangements where you've got a situation where the single vendor is doing everything. They're the trustee, the custodian, the record keeper, they do all the communications. Not that that's inherently bad, but it's something that needs to be evaluated in the context of the overall relationship with the vendor. Again, so you can kind of peel apart what it is you're paying for. And it also goes to making sure you're evaluating other alternatives as well as part of the prudence exercise. And then finally, regular evaluation and review. We obviously don't just put our agreement together, throw it in the drawer, and don't look at it again for the next 6 or 7 years or 10 years in some cases. We need to be evaluating this. I mean, the industry's changing. Dan hit on that before, where we've got this race to the bottom for fees, and a regular evaluation review of our agreements and the services that are being provided, the new services that are coming on board, is really, I think, critical to being able to demonstrate that you are on top of these decisions and you're understanding what's going on in the marketplace, so that your participants are getting the best plan for the best buck. I don't know, Dan or Andrew, do you have any other comments on best practices?
Yeah, just a couple comments. Talking about the closed arrangements, certainly there's nothing wrong with having your Vanguards, your Fidelities handle all or even most or even all of your services, right? There's definitely an economy of scale that happens there. Certainly not to say that that's inherently bad, but do just keep in mind, and this is particularly true for smaller plans, do just keep in mind that that your service providers are when they're pitching a new idea to you or pitching a new thought are salespeople, and they're trying to make money, which is nothing wrong with that. But you need to evaluate it like that, and your process should be more than just, well, it seems like a good idea. You should be thinking maybe it is the best idea, but you should also be thinking about your plan participants. Are there other options? And just again document that. And the last piece of advice I'll give is something I touched on before, and this is specifically for litigation, is just to be very careful about more formal requests for documentation and information. You can oftentimes tell when it comes from a lawyer. You'll obviously be able to tell something when it comes from a lawyer versus not. At least often you will. And I'm personally aware of 3 cases that were filed almost exclusively. Almost certainly would not have been filed if that process had been managed better. In one instance, some information that was very helpful to the company wasn't provided, and the plaintiffs had a wrong view. In another instance, information that was bad was provided when it didn't need to. So that's a very good way of making sure. There's only so much you can do, of course. There's the legal requirements, things like that, but making sure you manage that process and that it's not just handled by someone at HR who is perhaps not as sophisticated in the ERISA obligations under ERISA 401B. It's something that should definitely be managed appropriately.
Yeah, one other thing I might add on bullet 3, the expert advice and evaluation. Oftentimes we run into clients who utilize what I'd call would be their broker, who may have some compensation skin in the game. And from our perspective, a best practice would be to get a neutral party, a party that you're paying irrespective of what you do with the plan, whether it's a consultant like NEPC or your outside counsel or some other financial advisor that doesn't have any stake in the outcome of which vendor you're choosing, how you're doing the agreement, and that type of thing. We see it all the time, and it's sometimes somewhat frustrating.
That's a great point about the broker. It's the same issue as it is with the service provider. How are people? Always understand how people are getting paid, whatever that might be, and how that impacts your plan, and how can you either take advantage of that opportunity.
Great, yeah, and I'll add one more comment here, and I think we're getting to the end of the presentation, but the last bullet on the slide, regular evaluation and review. I think managed accounts is a good example of that. If you look at the last year or two, there's a couple of large record keepers that have entered the space with proprietary managed account products that have really started to drive down costs there. So if you looked at that 3 years ago and compared yourself to the market, if you have managed accounts, it may look a little bit different today. So that's I think a good point to finish on is not just doing the right things on the front end, but maintaining that throughout the relationship and reevaluating if these services are still worth it for participants and also cost effective. So I think I'll close at that point. We're past the 40-minute mark, and when we're talking about contracts, I think that's probably the limit to what the audience can handle. So I'm going to thank the co-presenters, both Tim and Andrew. This was awesome. Thank you so much for joining. And for everybody else, appreciate your attendance here. We'll have a recording of this that we'll be sharing with all the attendees and be available also on the NEPC website. So thank you all. Have a great afternoon.
Thanks, everyone.